The way I would like to engage with you today is to talk about pros and cons. So, for example, a great starting point might be, what are the top costly mistakes BC tech companies make with their IP? And then we're going to contrast that with, what are the 10 right moves to optimize and leverage your IP? So, I've put this together really just from a top of mind perspective, and you can read it as well as I can. I'll offer some speaking notes here, but these, because they're top of mind, are the ones that seem to come up the most across my desk. So the first one is really all about chain of title. And this comes up in the context of transactions where I'm involved largely for the purchaser, and it's usually a US entity coming into Canada and looking to purchase a Canadian tech company. And what they're looking for is certainty that the assets, the tech assets, which includes the intellectual property, are owned by the target company. And the way you do that is ensuring that you've got the chain of title very clear, that you've got assignments from all of your contractors, all of your suppliers. It's preferable to have an employee agreement or an employment agreement that expressly sets out that everything that's created during the course and scope of employment is owned by the company. And you would be surprised at how often this is observed more in the, perhaps in the breach, than just as solid business practice. And I recognize that as a founder, you've got everything to look after and limited time, limited money. But this is really quite simple to do. Get some standard form agreements, standard form independent contractor, standard form employee agreement. When you set up the company and you're a founder, there's a standard form assignment agreement. Just get those agreements in place and start to put them together, keep them in a place. This is something that when you go to exit after building your organization, after sacrificing years and of sleep and your retirement fund and everything else, you don't want to get caught with a discount on your sales price. You don't want to get caught with a holdback. You don't want to get caught with an indemnity that's got money associated with it, because the purchaser doesn't have certainty that there's clear title to the intellectual property assets. And one of the steps that I always take when I'm on for the purchaser is I insist that they get those taken care of. Now, just to take a step away from that, even just in the day-to-day transactions, if we were talking about this last year, I would have said to you, I've got a nice little side business going where companies that are developing apps and outsourcing the development, sometimes overseas to India, sometimes down to the States, sometimes locally, they do that without an agreement. And if you're in the digital technology space and somebody's developing code for you, I just want you to suspend your disbelief. If they're not an employee and they're developing code for you, they own the intellectual property in that code. They own the copyright, they own the moral rights. And so the side business I had was chasing those developers and spending the founder's money litigating to get those rights. In some instances, I've had to litigate to get the code because they've kept the source code, they've kept the object code, the things you need to advance the evolution of your technology, of your business. It just doesn't, it may start with a developer giving you a batch of code, but it's a living thing for you. So I'll stop there for a second and see if there's any comments or questions. And I'm very patient sometimes. Let's talk about another one that I frequently see, and that's just as it says, you've got an invention, you're really excited about it. Perhaps you're an engineer, and I happen to know a lot of engineers and may even be one. And you want to talk to everybody about your great idea, the problem that you've solved, and how you've solved it, and how it's better than the way anyone else has solved it. Well, if your idea is, for example, something that is patentable, it's around a product, for example, yeah, by disclosing it before seeking protection for it, you may have lost the opportunity to actually gain protection for it. So let me explain. In almost all of the jurisdictions in the world, if you disclose something that's patentable, it's deemed being dedicated to the public. You've given it away. Thankfully, Canada and the US are not in that scheme. But what it does in Canada and the US is it starts a 1-year clock ticking for you to get to the patent office and file an application for registration, something to protect it. But even that is suboptimal. And again, you wouldn't think that organizations, sophisticated organizations, would take an idea that somebody else has come up with or an invention and then seek to file a patent application on it themselves. Well, I can tell you that that happens. And the only winner there is the lawyers. If you sort of look back in some of the Alberta case law, you'll see that I'd filed a number of suits against a particular supplier whose project manager had come up with an idea for an invention. The supplier had then built that. And sure enough, the supplier went and filed the patent on it. And I found it because I was watching every Tuesday, beginning of the month, when the Canadian Intellectual Property Office publishes the patent applications after the period of confidentiality. I happened to see it. And truth be told, the exact drawing that was on the project manager's wall was attached as a schedule to that patent application. So it was really easy for me to take that one on. But again, suspend your disbelief. These things happen. So be careful with anything that you plan on building a business around that's going to generate revenue for you, that's going to protect your market share from others in the market, that gives you distinctiveness or exclusivity. Be careful with it, manage it as an asset, put confidentiality agreements in place, make sure you've got chain of title on it, do it before you start to engage your supplier to build it for you. Do it up front, get standard forms in place. Very easy to do. Feel free to drop me a comment or additional thought. I'm happy to respond to those as we go along here. So the next one is treating trade secrets casually. And that's just as it sounds. You really, if you've got something that either isn't patentable or maybe is patentable and it drives your business in some fashion, you want to make sure you know what it is. You want to make sure you put the safeguards around it so that it doesn't get out inadvertently or intentionally. And because once it's out, you can't close the barn door after that. Um, so I've got a comment here. Does an NDA cover my IP when outsourcing development? Well, an NDA offers some protection against that developer disclosing it, but it still doesn't create the ownership you require. And so what I'm going to say there is the Copyright Act, which is what governs software, primarily, not exclusively, but primarily, requires that the transfer of ownership is evidenced by a signed writing. So I don't make the rules. That's just what the legislation says. And yes, the Copyright Act is the subject of consultation in Canada. The federal government has just closed the consultative period where they were looking at modernizing it to catch up with privacy and AI evolutions, because those are C-scale changes to copyright IP, but nothing's happened yet. So get it in writing and get it signed. That'll get you the ownership. And that's what purchasers will be looking for, or buyers will be looking for when they look at the due diligence steps they take to identify the IP that you've got, how it supports your business, and that you actually have chain of title. So they'll be looking for those documents. We were talking about trade secrets. Trade secrets, algorithms, software, standard operating procedures for industrial technology. Uh, it has lots of different flavors. And it's so easy to disclose those in emails, to share those with other entities that you're working with. Well, that's a great question, and um, that's a conversation I frequently have with startups as they're headed into, for example, incubators, accelerators, even angel pitch events. Really, the question is, how much does your audience really need to know? Do they really need to know the nuts and bolts? Your best protection is always going to be to manage what you disclose, meaning don't disclose the crown jewels. And if it's really important that they need to know that information, like typically what I see are startups that want to talk about their technology, and they go to investors, whether they're VCs or angel rounds or others, and they disclose a lot of the crown jewels. But a lot of the audience aren't interested and really don't know what to do with that information. What they're interested in are the typical: who's your customer, what's your go-to-market strategy, show me your supply chain, show me your unit costs. None of that has anything to do with the secret sauce that you've come up with. So don't disclose it if you don't have to. If you have to, take the time to put a confidentiality agreement in place. Take the time to make sure that your disclosure is going to be protected, because it's just the beginning of a bunch of time, money, and resources you're going to be throwing at this to create a business around it, or to continue to grow a business that's already based on it. I've got number 4 on the list here is blank, because I was hoping somebody would just come up with one, and I think that we just heard that. How do you distinguish? How do you draw the line between what to share and what not to share? And so thank you for that. Another one is the brand. What are you going to call your organization? What's your trademark? Really an interesting question. A lot of founders get very invested in this. You want to do it right. There's a number of rules you have to follow. The primary rule being it's got to be distinctive. It can't be confusingly similar, or similar in a way that confuses the customer. So that doesn't mean that if a construction company that does bricks and mortar work has the same name you want to use for your app, that's that's confusing. You're in very different product and service markets. There's no overlap there. You're good to go. But just because you're invested in a name, don't insist on having it if you see that there may be challenges in the marketplace. And particularly in the US, where the litigation around this is incredibly aggressive and very costly. So aside from the notion of you've already invested in this, you've got your branding, you've got your website, you've got everything out in the marketplace, and you're going to have to change it, which is a tremendous cost. You don't want to suffer that, but you also don't want to attract you don't want to attract some of the big players in the market that just like to be bullies and look to establish a broader space than they're entitled to. So, not perhaps to mention any names, but there are organizations like ExxonMobil and like Apple that have very deep pockets and they watch. And if they see a brand that, for whatever reason, they feel infringes on the breadth of the recognition that their brand has, they're going to do something about it. And you don't want to be on the receiving end of that. It's just a distraction from your business and it's money and time that could be put elsewhere. It's also an interesting thought that when you, for example, what I've seen in the Canadian Trademark Office is when you file an application for a trademark, there's a community that looks at these applications and they go and check if the domain names have been acquired for those marks, word marks. And if the domain names haven't, they go buy them up and then try and extort you to sell you the domain name. Pick a number. I've seen $10,000. I've seen $25,000 where these, squatters seek to extort you. Now, there's ways to get over that, but the easiest way is when you're selecting your name, part of your branding strategy needs to be go to GoDaddy, spend the $100, get the 10 or 11 domains and subdomains that you can, and just be safe. It's small dollars at this point. So really try and cover that off. Look in advance, do a clearance search so you know what space you're playing in around the brand. Do the same in the domain area, but that's really easy advice. And again, I see there's ways of getting around it, but you don't want to go through those if you can just spend $100 up front. It's money well spent. And it's a lot more economical than calling a lawyer. So let's talk for a second about open source licenses. Tremendous amount of digital technology and excellent coders use open source code. Why wouldn't you? Thank you for that comment. Why wouldn't you? Right? It's efficient. It's already been done. There's all kinds of benefits. Again, when you're looking to sell or exit, the buyer is going to be looking for that chain of title. And the chain of title and the certainty that they're looking for includes looking at your open source hygiene. Have you identified the open source code that you're using? Do you know what license applies? Are you in compliance with your license? And certainly, have you selected licenses that don't require you to take the proprietary code that you've developed and deliver it back into the community? Are you aligned with the copyleft licenses? So this is increasingly a point of significant attention and scrutiny in purchase and sale transactions and the due diligence aspect. And there's lots of little reps and warranties I add to those sorts of agreements around that very point. Just pausing for effect and in case anyone wants to drop a comment in. So the next item on the list is 7, and it may seem that it's a little out there, but it's kind of a fun topic to talk about, particularly when you look at what recently came out, recently being last year in British Columbia, in the case Moffat versus Air Canada, where a family went online and were looking for purchasing a ticket under the bereavement pricing so that they could attend a funeral, and the chatbot messed up. Air Canada was held to the standard that what the chatbot says binds the company. Those reps and warranties, those statements are binding on the company. So be careful when you set up your chatbots to engage your customers. And if they're doing anything that has a cost, reputation, privacy, or other impacts, you want to manage that so that you don't get in trouble. Yeah, read the Moffat versus Canada case. That's a really interesting one. Just Google that and you'll find it real easy. How about freedom to operate? What is freedom to operate? What does that even mean? Well, what it means is that you've done enough due diligence in the technology or intellectual property space that you're looking at, whether it's trademarks or patents or other, to know that what you're going to be seeking protection over is not already captured by a third party, or that there's no overlap, that you've got all of the room you need to do what you want to do. And this is this is something again that in purchase and sale due diligence we look for. What sort of freedom to operate exercises have they done? But it's particularly important in the US because there are heightened penalties, if you will, if you don't do that well. So in Canada, there's the standard remedies, but in the US, they have what they call treble damages. I'm not going to go into a discussion on what those are or what they apply to, but I just want to make sure that you're aware when you play the game in the US, different rules apply, and it really is an elbows up arena that you're getting into. Number nine really speaks for itself. I find that when I'm involved in, I do a lot of technology procurement, cross border. I do a lot of data licensing, management, hosting, you name it. That it takes about 30 to 40% of the time that I spend on these to ensure that compliance is front and center. Um, this is a very dynamic space. You know that that in Canada there is not currently any monetary penalties that the regulator can impose for non-compliance, but the federal government has certainly telegraphed that they're going to go in that direction. We all know that GDPR imposes those, and while that's currently the high watermark in the privacy space, and it's what we all sort of look to when we're putting our agreements and our standards and practices and protocols together. It's not something to take lightly, um, and that's the regulator is really a secondary consideration. If it's your customers or your members, those should be your primary consideration. I was on a call this morning actually on exactly this topic, where the US supplier was offering contract terms that would deny our Canadian client any compensatory recovery in the event of a data breach or a privacy breach. Very common contract position, even from Canadian suppliers. But if you don't look for that in your agreement, it's easy to overlook. It's a very nuanced legal concept and term in the agreement. And our comment was, we will die on this hill and we will not sign the agreement unless you're prepared to relax, or as we call it, carve out certain losses from that particular term. So if you're working on an agreement where sensitive information, personal information is involved, and it seems to be going so well that you're going to sign and it hasn't been discussed, I'd suggest pausing. So the last one is really just keeping your eye on the ball when you've got a business to run and an unlimited number of issues to manage, an unlimited number of balls that are in the air. This is one you don't want to drop. So the government, once it grants you your intellectual property, your registered intellectual property, like a patent or a trademark, that's not the end of it. Oh no, they want to make sure that you are an annuity for them, that you continue to give them money to maintain that registration. And we call that a maintenance fee. You have to pay those. If you don't pay them, it used to be that you could repair that or you could cure it. Uh, no longer. The defect can and is fatal if you let those lapse. Doesn't matter why. So you need to, it's very easy. It may only be a couple of $100 and it may only be, once a year or every couple of years, but put it in a docketing system, make sure you pay it, and then don't worry about it. The law firms are all set up and the IP firms are all set up to do that. We've got great big machines that do that. Take that risk off your back and just send you the bill every once in a while. It is an excellent question because you have a limited amount of funds. You have a limited amount of time. And I can tell you, I frequently have people coming into my office and saying, I need a patent. And I say, well, maybe you do, maybe you don't. Let's talk about that for a second. And one great example that comes to mind for me is a number of years ago, I had a woman come into my office and she proudly showed me her patent in Japan, her patent in Korea. And she said, what do you think? And I said, immediately said, I think you should abandon them. I don't think at this stage and with your business, you have the time, money, or the boots on the ground in those jurisdictions to actually have a line of sight on infringers, to enforce it. You need to think intentionally about where you're going to focus and how you're going to do it. And that was money that really wasn't well spent. And there's a number of things we can talk about for deferring costs if you really need to go into those jurisdictions through, for example, the Patent Cooperation Treaty. But that's getting ahead of ourselves, I think. Chris, your question was, when do I do it? And I think I would ground that answer in the notion that if you've got intellectual property that generates a revenue stream or provides you some competitive advantage, that's your trigger right there. Now, we can talk about defensive strategies. So patenting can be offensive and defensive, but that's a larger conversation around landscape searching and competitors and where the research and development trends are, a whole host of different variables. But I think, to answer your question, I would say when it's protecting a revenue stream or some competitive advantage. So that's an outstanding and very insightful question. And I've got a great answer for you. Again, the client that I was working with this morning in preparation for our negotiation, I had prepped them on why we needed this particular contractual position. And then to your point exactly, I was able to quantify it by saying, here's the dollar values we can associate with a breach for you. And the way I did that is there's a benchmark that comes out every year. It's the IBM data breach report, and it looks globally at various sectors and the costs associated with data breaches to the owner company. And it's a publicly available report. In fact, I downloaded the 2025 a couple of weeks ago. It changes every year a bit in how user friendly it is, But that's the best source I've found to be able to, on a principled basis, negotiate and inform negotiations on what the cost implications are. So the financial services sector was the discussion I was having this morning, and the dollar value in the report was about $8 million. So that's a hard number that we can say the cap on liability you're looking for isn't commercially reasonable for us because we've got some hard data that shows these are the sorts of losses and this is the sort of quantum, the amount that we can expect. So let's manage the risk where you take that on rather than us. So I'd encourage everyone, if that's part of your business or you're in any one of those sectors, that you take a look at that. So these are, these may seem self-evident, but they're not. That's why they're on the list, right? So the way I would talk about the first one is be intention, have a strategy. What your strategy does is it aligns the assets you have with your business. The intellectual property strategy drives your business strategy drives your intellectual property strategy, not the other way around. A patent is a patent is a patent. You can get anyone to sell it to you, but unless it's driving or supporting your business strategy somehow, it's just not worth it. So again, patents, revenue, distinctiveness. Um, it is really good if you've got a development roadmap for your product, your software, whatever your business is aligned with, to have that strategy and to be able to look at it as your business evolves. What to patent, what to keep as a trade secret, what to brand aggressively, how often to revisit it. Then you can budget for it. Then you know where your money's going. You know how to prioritize it. You know how to prioritize your money. You can talk about it. When I do due diligence on acquisitions, I always ask for a roadmap. When I do contracts with suppliers, and the contract is existential, if you will, for the company that I'm working for, I ask for the roadmap. Because if the organization is procuring a technology that it's basically the heart and soul of the business, we want to make sure that the vision they have for that technology aligns with the roadmap for the company, but also it's it's important if you as the purchaser want certain features or functionality to understand where it is on the roadmap and to be able to negotiate with that supplier to fast forward that for you so you can benefit from it now. And so there's lots of really positive ways that the two organizations can work together there for their mutual benefit and the benefit of all of the other customers for that supplier. Just saying. So the next one we've talked a lot about, and that's getting that chain of title, getting those standard forms. Just do it. Every law firm that operates in the startup space or that has a tech group, they have startup kits. They're cheap. They've got these standard forms. There's no excuse. They'll show you if they do it right. They'll teach you how to use the forms so you can use them in your business and not have to go back to them every time. It's just good business. Trade secrets, know what they are, put the protections in place, have the protocols set up. When again, due diligence, I ask for the trade secret list, I ask for the protocols. I want to know that if they've actually got a trade secret and that trade secret is essential to the business, that they've taken care of that asset. Just like buying a car, I want to know when the last oil change was, if they've changed the timing belt on time. File patents where it matters. There's strategies and what you put in a patent, what you don't. And I'll leave aside the statutory requirements for what needs to be in there and enabling disclosure requirements, but there is intentionality that goes with it. When you're going to disclose your technology, if it's patentable, the best practice is to get a patent application in first, then get an NDA, then disclose it. If you can't get the NDA, well, you've got some measure of protection if you have to disclose it. What jurisdictions do you file in, and why, and when, and how? These all have cost impacts. These are all questions that investors ask. These are all questions that, your purchaser is going to ask. We've talked about a trademark strategy, branding strategy. We talked about open source policies. We haven't gone deep into the privacy by design and privacy. That really merits a whole separate conversation, um, and might be something BC Tech thinks about for future programming. We've talked about freedom to operate, competitive landscape reviews, know your competitors, know where they're playing, and know how they're playing in that IP space, because those are the rules of the game, and it is an elbows up game. And then sort of the last one is, if you've done all of that homework, if you've done it all right, don't give it up to get that first contract. Don't give it up in your contracts with your big customers, uh, vendors, affiliates, distributors, partners, whatever it is. Uh, Keep an eye on the ball. In Canada, we're operating in a vacuum right now. You all know that the federal government had tabled the Digital Charter Implementation Act and the Artificial Intelligence and Data Act, that it had intended on modernizing privacy and regulating AI in Canada. Those died this year. So we don't have anything. Something's going to come. I don't know what it is. But until then, what should we do? So when I think about it, so we've got that vacuum. We also have the modernization of the copyright consultation that has just concluded. And that consultation identified some very a very significant difference in viewpoints from those that create copyright to those that use it. So the authors versus the consumers. Very polarized, very different positions. I don't know where that's going to go, but there's going to be a change in that landscape. So I think the way we try and conduct our business now is we want to make sure that we understand the AI tools that we're using. We want to be able to be transparent with those. So we want to know what we're putting into the tool. We want to know what's coming out of the tool. We want to know what the tool biases are. And there's reasons for all of those. So what we put into the tool, we want to be careful of confidentiality, personal information, and copyright. These tools, as you know, many of them make that information available, that it becomes public domain information. So there's a tremendous amount of exposure for you there. So let's manage that well. The sort of the bias, if you will, is let's understand where the tools are good, where they're not good, where they need the human in the loop. So where do we know that the tool is not going to execute correctly or in a way that protects us? Let's get a human in the loop to be the qualifier, the verifier that we want to take the next step with that information, or do we want to iterate? And then, of course, what comes out, we want to make sure that is compliant. So there's, I was thinking about this before the call, and I think what we do is we manage on a transparent basis that data chain of custody, if you will. And we do it in the context of an AI policy that we put together. And There's a number of emerging frameworks that are coming out around AI. So ISO has one, NIST has one. The UK government came out with 5 AI regulatory principles and some guidance. Uh, there's a lot of work to be done still, but there is information that's becoming available. So, let's do that. Let's also be mindful of chatbots. Let's not start scraping sites for information. There's a great case on where Auto Trader was involved that we should all look at. Let's you know let's honor terms of use, and let's just be focused when we enter this space and play in the space. Well, for what they're worth, now's the next best time. No matter where you are in your journey, now is the next best time to start paying attention to this and making it part of, I worked with one fellow that said he had a suck list, the things he didn't like to do, and legal and IP was on his suck list. At least it was on his list. I was happy with that. So now's the next best time.